This is of 8 November 2010. Guidelines under Section 35 of the Right to Free Education Compulsory Act for implementation of the provisions of Section 23G. This has been issued by MHIT, the nodal department of the central government. National Council for Teacher Education has, in exercise of the powers conferred by Section 23(1), laid down the minimum qualifications for a person to be eligible for appointment as a teacher in schools, vide notification dated 23rd August 2010. This notification has already been circulated to the state government and the other authorities. The notification can also be downloaded from the website. Accordingly, all appointments of teachers, kindly consider your lawsuits, in classes 1 to 8, in respect of all schools referred to in clause N of section 2, I have taken your lawsuits to that because of this, have to be made in accordance with this notification. That's why I'm harping before your lawsuits. Even in the private school, if you are a recognized school, you are coming under the 2N. First of all, you are not coming under 2N because these are unrecognized. If they can show, that's another issue. I do not find from the pleading or from any document. Secondly, even if you are recognized, you have to comply 23rd August 2010. That means higher secondary year lawsuits, 50% marks and 2-year diploma. That was relaxed, your lawsuits. But what not relaxed, I will take your lawsuits to that. Lord, your lawsuits will find in 23rd August 2010 notification. I need not place it, your lawsuits. State is a must. Now your lawsuits of this notification I handed up, clause 4. The condition of passing TET will not be relaxed by the central government. So one cannot be appointed even in unaided private recognized school without TET. You cannot. That's why your lawsuits, TET, the certificate is valid for indefinite period, for whole life. Why? If you cannot secure an appointment in aided school government job, you can do it with this qualification in private schools. So this was not relaxed. But what is their case before your lawsuits? In 2017, as in-service teacher, I'm sorry.
Yes.
In 2017, as in-service teacher, they admitted themselves in the course, and 2019, but when they got the TET pass, that your lawsuits, all are TET pass in 2022. Page 122, your lawsuits kindly. One of the certificate.
Others have not passed.
All passed 2022. One I am showing to your lawsuit, they have annexed. Probably they have annexed others also. Not all. 2022, I am on what? On clause 4. So when you are appointed without passing TET, how could you be appointed? It's an illegal appointment. Even the school is recognized. Because you did not qualify, fulfill the conditions of NCT of 2010. So without TET, you are in service teacher, which you could not be. Now, law is as of today, after 2010 August, even in recognized private school, authority cannot appoint a teacher without compliance of 23rd August 2010 in primary schools. We are not, we are duped. We are duped by the authorities because we do not know. Most of our children are in the private sector. We do not know how many of them have TET pass. This is an illegality. But court cannot be a mute spectator to this. You cannot get the reap of the benefit on the basis of your illegalities.
As per the averments in the writ petition, they are all past date 2022 or
exactly 2022. So they could not sit for school. The authorities did not verify all this. This was not the case either before the Honorable Supreme Court. Supreme Court issue was only whether those who passed DLED in 18 months as in service, whether they can be allowed to participate in the next recruitment process. Ultimately, issue was that whether this is at all a qualification for the recruitment purpose. Initially said, my lord, in Jaibi Singh, no. I will take your lordships. So for the factual background is, these are the factual.
As per you, before the Honorable Supreme Court, the other conditions were satisfied by the petitioners before the Honorable Supreme Court.
I am not sure in that.
না না না
I'm not,
সেটা নয়, তার কারণ হচ্ছে আমাদের ওইখানে যে অর্ডারটা ছিল আমরা 30/5 এই যে এইটা দিয়েছিলাম না 30
no, that's your lordships. I will clarify that. That was not there. And that was, my lord, not before the Supreme Court also. We have clarified that. And today I have come to know that in 2022 selection process, we wanted to verify all these and issued a notification. They questioned it before the Supreme Court, relying upon Kaushik Chand judgment. So probably they have withdrawn it today. I've got the judgment, seen the judgment today. I will show to that. So our requirements, my lord, as today, my lord, that's valid what we are asked. But we are, that's a 2020 selection process. That was during the pendency. But this is, my lord, just to have started. They have to satisfy your lordships. Or the petition will show. Why should I allow a candidate, my lord, who doesn't fulfill the conditions? Prima facie. His document shows that he is not entitled to the benefit of 18 months courses.
Yes.
Now your lordships, I take your lordships to the JIBC judgment ana okay.
কোনটা
ওই যেটা আজকে হলো দেখলাম একটা কোথায় হয়েছে
এইটা
না উইথড্র করে নিয়েছে কবে দেখলাম আজকে ও আচ্ছা সেটা আমি দেখাবো Now your lordships have been shown the main judgment of JB Singh of dated 28th November 2023. I just take your lordships to that judgment. না এটা তো জয়বীর সিং এর মেইন জাজমেন্টটা কই
এইটাই তো মেইন জাজমেন্ট
23 আগস্ট কি
হ্যাঁ
না দেখছি
এটা রিপোর্টেড কপি দেখি তোদের কি কপি আছে রিপোর্টেড কপি এটা
না এখানে তো হোল্ড করলো যে
Paragraph 41.
মানে the paragraph where because online মানে and another এটা কি জসিম প্যারাগ্রাফ
জোসেফকে দেব
দেখি না জসিমকে দিয়েছে ওরা
The paragraph where Ram Saran Maura has been quoted, just
paragraph
where Ram Saran Maura has been
আচ্ছা just a minute
discussed, just prior to that paragraph.
এইটাতে আমি দেখিয়ে দিচ্ছি এইটা দেখিয়ে চল 56 প্যারাগ্রাফ 56 ওরা দেখিয়েছে
না
41 জজ সাহেবের ওখানে 41 প্যারাগ্রাফ দেখিয়েছে যেটা এখানে আমাদের এটাতে
না মিলছে না তো এখানে
এইটা আমাদেরটাই মিলছে
ইন ভিউ অফ
হ্যাঁ এইটা ওরা দেখিয়েছে কিন্তু আমরা তার আগে থেকে দেখি
হ্যাঁ না কোথায় যেন হোল্ড করলো দুটো ইকুইভ্যালেন্ট নয়
হোল্ড করো
Para 41. Para 41 last.
মানে that paragraph I'm noting is different মানে your lordships paragraph 41 এইটাই তুমি দিয়েছো তো
না না
তোমারটা হ্যাঁ
এটা আনরিপোর্টেড এটা
আর জজ সাহেবের কাছে এটা আছে তো
হ্যাঁ, এটা আছে।
সেটার জন্যই তো আমি চাইছি জজ সাহেবকে কি করে অ্যাসিস্ট করবো হ্যাঁ now paragraph 41 in view of what has been held by this court herein above we find that the high court erred in holding that 18 months diploma conducted by NIOS through ODL mode is equivalent to the 2 years regular diploma. Initially court held this, it is not equivalent. You cannot do that. Then the question come up, your lordships will find page 208. Your lordships kindly come. Here I will show your lordships certain things. Page 208, it starts Vishwanath versus Uttarakhand. That judgment. This is order dated or judgment dated 5th March 2025. This was, if I am not wrong, under review.
Yes.
Now I will be placing some of the paragraphs of it. Why I am saying all this factually I had taken to your losses. To paragraph page 209, paragraph 3. In 2017,
Paragraph
3 at page 209. Kindly see the dates are almost coinciding with their appointment letters, all that. In 2007, an amendment had been carried out to the Right of Children Education Act 2009, which clause 2 was inserted in section 23 of the Act. The Right to Free and Education Act 2017 was made retrospectively applicable from 31st March 2005. Pause here for a moment. I had taken your losses to the sum of the letters of 2015. Why? Because of this. They obtained it subsequently. It's a private school. No preparation of documents required. On the letterhead, issue the appointment letter with a retrospective date. To cover up this gap and show that I am in service teacher, I will show that, your losses. It was provided that every teacher who had been appointed or was in service on 31st March 2005, 15, but did not possess the minimum qualification of 2 years as laid down under subsection of section 23 would acquire such minimum qualifications within a period of 4 years from the date of commencement of the Act of 2017. Therefore, what happens to your lordships? If you are in service teacher on 31st March 2015, you have to complete it within a period of 4 years. But that amendment came into effect of 2017. So what actually happened if really a bona fide teacher is there? Because of retrospective effect, he lost 2 years. Clear to your lordships? Out of 4, he gets only 2 years more. Because of this, MHRD by notification of 2019 extended 2 years more for them. But what happens here, I will take your losses to judgment. Kindly visualize their appointment letters. All of them secured. Somebody more intellectual, they got it 2014. Somebody just give me before that to show that I am on service on 31st March. Nobody is there to check up these records. Because this was an ODL method. 18 months course, it's not a regular course. Got the one-time benefit, showing you in service teacher. But what else could be a fraudulent act on the part of these petitioners? Just to take the swallow the benefit of someone else's. You could have completed in the regular course. To avoid this, you have done this. Now see your losses. 4. In view of the provisions of the second proviso to subsection 2 of section 3 of the Act, Ministry of Human Resource Development had issued a letter on 3rd August 2017 to all the secretaries of the state and union territories, directing that all the teachers in government school must possess minimum qualifications as mandated under the RTA Act, and the last chance being given to all such teachers to acquire minimum qualifications till 31st March 2019. I said it because of this, MHRD extended 2 years more. Because Act was given a retrospective effect.
Yes.
So they lost bona fide teachers, if anyone. They lost. That's why then. Next, then kindly see paragraph 5. Since the time gap between 31st March 2015 as provided in the 2017 Amendment Act and 31st March 2019 as specified in the direction issued by the MHRD was 18 months. The NCT issued a recognition order dated 22nd September for conducting DLED program through web remote by NIOS through SAM portal of MHRD for in-service untrained teachers at elementary level working in the government unaided and unaided private schools. So what I am allowed, this is only for training qualifications. Very paragraph 4, your losses is only those who are possessing the other qualifications. Your losses getting it in the paragraph 4, last 2 lines in the page 209, directing last 3 lines, directing that all the teachers in government schools must possess minimum qualifications add under the RTA Act, and there's a last chance. Government schools, my lord, here, later clarified that unaided private school also. But no clarification is needed because section 2N, you were covered by that. How could you ignore the notification of the NCT? Because you are governed by NCT also. Now, here your lordships, what the court said, your lordships, kindly have a look at this. Kindly have running page 214. This is from Uttarakhand. Whatever I will the judgment appears, I have to accept it. Now kindly have a look. Paragraph 15. The grievance of the applicants herein is that though they are eligible as per the original judgment of this court dated 28 November 23 and the clarification dated 10 December 2024, in as much as the advertisement in the state of Uttarakhand dated 29th May 24, that is after the judgment was delivered on 8th November 2023, the state of Uttarakhand is not considering their claim. Here, my lord, there was an interlocutory order. Your lordships will get it. That in paragraph 20 of this judgment in next page. Why I'm placing it? That might be they satisfied they are qualified otherwise in service all that. But that was not the scrutiny before the honorable court.
Yes.
We are before the first court of the honorable high court. So we are showing before lordships they are not eligible to undergo the 18 months course. Now, your lordships kindly come to paragraph 20. No doubt that this court has upheld 2012 rules framed by the state government by the judgment dated 28 November 2023. However, at the same time, this court had clarified that such of the teachers who were already in employment as on 10th August 2017 would be entitled to benefit of one-time scheme provided by the government of India. This court had held that such of the teachers who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or promotional avenues. Paragraph 21 is relevant, my lord, because, indisputably, the other institution would also include the schools run by the state government. Now, what they are now trying? In a backdoor process, you have secured 18 months course degree or diploma. Now you are asking this benefit of this. Allow me to appear like 2 years courses. This is a fraud, my lord. Why the genuine candidate will be defrauded by the authorities?
And they, my lord, cannot derive any benefit in respect thereof. The writ petition should be dismissed.
Mr. Dasgupta, those two matters, 256 and 257, I am passing a single order, making it with, because at that point of time, I was of the notion that one of the matters with 22 and 23 and rest was with, but I find that they are similarly circumstanced, so passing a single order.
One single order?
Yes, with. Sure. Yeah. Oh. Yes, Mr. Chatterjee.
I need some time. Can I come back tomorrow?
When? Not tomorrow. After the vacation, I'll take it up.
There, anything
After the vacation, we'll do that. In the first week itself, I'll take it up.
kindly fix a date.
Yes. Affidavit of service, Mr. Chaturvedi. Can 1 of 2025. This is an application for affidavit of service filed on behalf of the petition is taken on record. This is an application for
My lord, I have a letter, my lord, I shall affirm in course of the day and may not file it.
Mr. Chaturvedi, learned senior advocate appearing for the petitioner, undertakes to file the affidavit of service. This is an application for addition of party. The petitioners contain that they are. Which paragraph? You have filled your form or you are aspiring to participate in the ongoing process?
Yes,
We have filled our form. Lord, paragraph 4.
your paragraph.
Paragraph 4, supported by the annexures in P1 collectively.
The petitioners Not 4,
Not
not
paragraph 35 of my application, I have stated
25.
35, 35. And the documents are at page 76 onwards.
They are candidates who have applied for participating in the ongoing recruitment process with a notification dated 25th September 2025, number 35 in Yenavel, read with notification number such and such dated 19th November 2025. They seek for impleading them as a added respondent. Mr. Chaturvedi, Piyush Chaturvedi, learned senior advocate appearing for the applicant, submits that the rights of the petitioners are very much will be affected by the prayers made by the petitioners, and as such they are necessary party to be impleaded in the present proceedings. Mr. Sobhusaji Chatterjee, on the contrary, Mr. Sobhusaji Chatterjee, learned advocate for the opposite parties, respondents, opposite parties, submit that the petitioners are no way, the applicants are no way affected by the prayer made by the petitioners, and therefore their prayers should not be allowed. Para, it is not in dispute that the petitioners are applicants in the ongoing process of recruitment initiated by the West Bengal Board of Primary Education pertaining to notification dated 25th September 2025. Thus, this court finds that the applicants are necessary parties. Accordingly, the applicants are added as
8 to 11.
respondents numbers 8 to 11 in the present proceeding. 8 to 11
My lord.
in the present proceedings. Can 1 of 2025 is accordingly disposed of. The name of the applicants be added in the array of the writ petition, array of the respondents in the cause title of the writ petition. এবার writ petition heard Mr.
No. Amended cost title maybe.
Amended cost title, I'll provide them.
Learned advocate for the advocate on record for the petition is directed to serve a copy of the amended cause title to the learned advocate for the respondents. WP heard Mr. Sobhusaji Chatterjee, learned advocate for the petitioner, who concludes his argument. Mr. Subir Sanna, learned advocate for the board, also concludes his argument. Next argument is also concluded on behalf of the added respondent number 8 to 11. Mr. Chatterjee, learned advocate for the petitioner, seeks accommodation to place his replies. Is this matter date বলুন জানুয়ারি প্রথমের দিকে বলুন 9th January.
Lord, arguments are concluded. Arguments are concluded by the respective parties. Will it be my lord's pleasure to keep it as a matter heard in part? Because my lord has heard everyone. I don't think Mr. Chatterjee would object.
Thing will change.
Lord, item number 600. Lord, item number 606 will be taken up tomorrow at the top.
Don't know.
There is urgency, my lord. 1